Respectfully, I believe the Supreme Court's recent decision in the Autozone case was a bad decision. Um, and this is, if you watch any of my videos, I always recommend and emphasize that injured workers should do everything they can to return back to work. I think an individual is always going to benefit from working, whether they are able to work in a full duty capacity or whether they could do a light duty capacity, or perhaps whether they find new work options via the vocational rehabilitation program. But I always think that should be the motivation. If you get a work injury, get healed and they get back to work. And I think this decision has a chilling effect on folks returning back to work in a light duty capacity, because when you return to work in a light duty capacity, then now you're at risk for the fact that you may be terminated whilst you're working in a light duty capacity, and then you may not then be able to file for temporary total disability, nor may you be able to find a new job because you're still suffering from the issues from your work injury in the first place. So that's why I think it has a chilling effect on returning back to work in a light duty capacity. And I think returning back to work in a light duty capacity should be a primary motivation for Ohio and Ohio injured workers and the Supreme Court. And why? Because, again, this benefits the injured worker. This benefits the employer because they don't have to train up a new worker, and they could still use that worker with their wealth and knowledge in the job, even if it's in a light duty capacity. And it benefits the economy of Ohio, and then it also contributes to the tax base of Ohio. So I think the 10th District's interpretation of 412356F was the correct interpretation. Essentially, if you're unable to work due to the reasons directly related to the work injury, then you're entitled to temporary total disability compensation. You didn't have to then go to the second sentence, whereas now with the Supreme Court's interpretation, it doesn't matter if the first sentence applies. If the second sentence applies, i.e. if you're not working for reasons directly unrelated to the work injury, then you're not entitled to compensation. So again, I think it's a bad decision, respectfully, and I do think it has a chilling effect on this primary motivation of everybody, which should be to work. So that's my personal opinion. You may disagree, but anyways, keep getting better, folks. Keep trying, keep pushing.